This is case number 18-12043, FH, People versus Lori Pressler. Ms. Pressler was set for a probation violation hearing today. The hearing was set for 1:45. She's attempting to appear via Zoom. Doesn't appear to know how to use the audio. And Ms. Frisbee, did you practice this Zoom technology with your client as the court directs in all cases?
I did in this case because she said she will download it and she knew how to
Just
use it.
unmute.
Well, apparently she doesn't.
I've used it before. Excuse me, can you hear me, sir?
Now I can, yes.
Okay, I just unmuted.
All right, thank you. So in this case, we're set for a probation violation hearing today. And
You're
Ms.
welcome.
Ms. Pressler, do you understand that you have the right to be physically present in court if we were going to have a contested hearing regarding these probation allegations?
Yes, I do, sir.
You also understand that if you enter a plea and we move to sentencing today, or if you're found guilty after a contested hearing and we go to sentencing, that you would have the right to be physically present in court for sentencing as well?
Yes, I do, sir.
All right. And do you waive or give up your right to be physically present for the probation violation hearing and for sentencing?
Yes, I do, sir.
All right. The allegations in this case, Ms. Pressler, was that you were placed on probation to this court on or about April 9, 2019 for the felony offense of possession of methamphetamine. It carries a maximum penalty up to 10 years, and your original advisory guidelines were 0 to 11 months. Do you understand that?
Yes, sir.
All right, and you are alleged to have violated your probation, condition 2.4, that you not use or possess any controlled substances, and on or about August 24th, 2020, that you used the controlled substances methamphetamine, and you admitted to your probation agent that you had used those. Do you understand the allegations contained in count 1?
Yes, sir.
Count 2, that you violated condition number 2.4, that you not use any controlled substances, and on or about August 24th, 2020, you admitted that you had used marijuana. Do you understand that the allegations contained in count 2?
Yes, sir.
And finally, count 3, that you violated condition number 1, that you not violate any criminal law of any governmental unit. And in that on or about August 24th, you admitted to having prostituted yourself on several occasions between January 7th, 2020 and August 24th, 2020.
Then
Understand the allegations
not the correct
contained?
date. I did that 3 days ago.
Well, do you understand that those are the allegations raised against you?
When my house was being foreclosed.
I'm not looking for an explanation. I'm just asking you if you understand that's the allegation.
Yes, sir. Right.
Okay. All right.
Yes, I do, sir.
Thank you. There's been a recommendation made by the probation agent such that if Ms. Pressler were to enter a plea of guilty to one or more of these allegations, that they should be sentenced to 330 days in the Newaygo County Jail with credit for 192 days, and that she'd be revoked unsuccessfully from probation. Mr. Stade, do you adopt that recommendation as an agreement in this case?
The people do, Your Honor.
Is that your understanding of the plea agreement, Ms. Frisbee?
It is, Your Honor.
Is that your agreement as you understand it, Ms. Pressler?
Yes, sir.
Okay. And Ms. Frisbee, I think you indicated that she was going to plead guilty to count one.
Yes, Your Honor.
All right. All right, so Ms. Pressler, the plea agreement in this case is if you plead guilty to violating count one, that would be for using methamphetamine. The plea agreement is that you would serve 330 days in the Nuevo County Jail. You get credit for 192 days, and that you'd be discharged from probation. Is that your understanding of the plea agreement?
Yes, sir. Christine.
Have you had sufficient time to consult with Ms. Frisbee about your original probation charges and this plea agreement?
I would like to, yes, I would like to talk to her a little bit more, though. I mean, there was a few things that we discussed that would,
Talked to her for half an hour, about an hour ago.
yes, we did. But I was asking if I could probably have rehab, if I could go into rehab at all.
I'll address that at sentencing. We're not to that point yet, Lori.
All right, do you need more time?
Oh, okay, I'm sorry. I'm sorry.
She's fine.
Do you need more time to discuss with Ms. Frisbee about the rights that you
Okay, I
have to
misunderstood. I'm
contest?
sorry, Christina. Yeah,
No, just listen,
I said
please.
that.
Do you need more time to talk with Ms. Frisbee about your right to contest these allegations at a hearing? Or
No.
are there things
No,
that you...
sir. I've had plenty, we did,
Will you please stop interrupting me?
no, I do not need more time. I'm sorry, sir.
Okay. Subject to the plea agreement, how do you wish to plead to violating your probation? How do you wish to plead to violating your probation?
Hear anything?
How do you wish to plead to
Come on.
violating your probation, ma'am?
Guilty, sir.
All right, thank you. Do you understand that if I accept your guilty plea, that you're giving up your right to have a trial of any kind?
Yes, sir.
Do you understand that by entering this plea, you're giving up certain rights that you would have at a contested hearing? We've listed those rights for you on a advice of right sheet. Did you understand those rights?
Yes, sir.
Did you read that document?
Yes, sir.
Do you have any questions about the rights that you're giving up by entering this guilty plea today?
No, sir.
Has anyone threatened you to get you to make this plea?
No, sir.
Has anyone promised you an outcome different than what we've talked about in court today?
No, sir.
Are you entering this plea of your own free will and free choice?
Yes, sir.
Do you understand that if I accept this guilty plea, you're giving up the right to later claim that the plea was the result of promises, threats, or inducements that you don't tell me about today?
Yes, sir.
Do you understand that I'm not bound by this plea agreement, but if I don't go along with it, you can withdraw your plea?
Yes, sir.
You now give up your right to contest these allegations at a hearing and all the rights that you would have at that hearing and affirm your guilty plea.
Yes, sir.
Are you pleading guilty because you are guilty?
Yes, sir.
Is it true that on or about April 9th, 2019, you were placed on probation to this court for the felony offense of possession of methamphetamine?
Yes, sir.
Was a condition of your probation that you not use any controlled substances?
Yes, sir.
Did you violate that term of your probation by using methamphetamine?
Yes, sir.
And did you snort it, smoke it, ingest it, eat it? What did you do?
I snorted it.
And did you, when did you do that?
It was during the time I had a really hard time with my husband's death this year for some reason. It's been 8 years. I don't understand why I'm having such a hard time. I have been into a couple of major panic attacks and I just relapsed.
All right, so that was in the last couple weeks, is that correct?
The end of August, yeah.
All
It was
right.
our anniversary. Our wedding anniversary, my birthday, his birthday, his death. All that is in like 2 months' time. And I've been to counseling 5 different times for this grief thing.
All right. Are the attorneys aware of any promises, threats, or inducements which have not been stated on the record?
There have been none, Your Honor.
No, Your Honor.
Is the defendant competent to enter this plea?
She is, Your Honor.
Yes, Your Honor.
Has the court complied with MCR 6.302?
You have, Your Honor.
Yes, Your Honor.
If the court does accept the plea, I do find it to be knowing, understanding, voluntary, and accurate. There's been an updated pre-sentence investigation report. Do the parties wish to proceed to sentencing today?
People do, Your Honor.
Yes, Your Honor, I agree.
Was the report timely made available to you?
It was.
Yes, Your Honor.
All right, and Ms. Frisbee, have you had the opportunity to read the report and discuss it with Ms. Pressler?
I have.
Do you have any additions, corrections, or challenges to that report?
No, Your Honor.
Is there anything that you'd like to say on her behalf before the court imposes sentence?
Well, my client, it's not really an excuse for relapsing, but she did lose her husband, and that was very difficult for her. She's been through the KPEP program, but I think she needs additional rehab. I would like to see her, if she does some minimum amount of jail, and the probation department looks for something, a place where she can go for inpatient treatment. She has a lot of anxiety about going back to jail. I remember when I did previously represent her, she was housed with a federal inmate that assaulted her. I mean, she had black eyes, she had her arm in a brace, she had big chunk of her hair missing. I mean, she was really beat up. And they didn't really treat, they gave her an ice pack for a couple days, took it away, never gave her any aspirin or ibuprofen or anything like that for her to treat her injuries. So she has a lot of anxiety about going back to jail and what could possibly happen there. So that's why I think that rehab would be the best course of treatment for her. I think that'd be the most beneficial. She'll admit she's an addict. She has a very bad problem, and it's not getting any better by just having her sit in jail for, how many months she's got to go. So in light of that, it looks to me that if she gets good time credit, she'll be in there a little less than 4 months, just shortly less than that. I'm not really sure, but so I'd really like to see her go to rehab. That's really the only thing that's going to be able to help her. Thank you, Your Honor. And also, Your Honor, she needs a couple more days to make arrangements for her pets.
Nice.
All right, Ms. Pressler, have you had the opportunity to read or review the report with Ms. Frisbee?
Yes, sir.
Do you have any additions, corrections, or challenges?
Just that I know I'm an addict. I know I was clean and sober for 14 years. I want to get back to my life, but I know I need help. I really want to implement rehab, and I really want to work hard at this to get back to where my life was. And I do know sitting in jail is not going to do that for me. If I could get rehab, I could get back to my life, back to my grandkids, and back to my kids. I relapsed once, and I just am asking the courts if they would please let me do rehab for that, to get myself better and get counseling and maybe help me with all this anxiety. And I own my own home. And I do need just 1 or 2 more days to just get things finished up. buttoning up my house for the winter. If I could please have that.
Mr. Stay, any additions, corrections, or challenges?
No, Your Honor.
Anything that you want the court to consider?
No, I believe the court's fully advised in this case.
All right, Ms. Pressler, you've known this hearing has been coming for several weeks.
It was only 2
Why are you
weeks.
why are you waiting to the last minute to get your affairs in order?
Sir, I didn't. I did. It's only been 2 weeks, and I just didn't. I've been working on it. I've been working on it. My daughter and I we were gonna. She was gonna help, but then they ended up having to move, and I tried to. A bunch of things came up. And my wallet got lost. I had to do a whole bunch of new banking stuff, new bank card. I have to get my mortgage payment switched over to the new card. I started doing that, and I still have to finish processing that because of disabilities, on one card. Part of it's going on one card and part of it's going on another. They haven't coincided with it all yet. I've been working on it, sir.
Agent Grutter, what do you think? Does she deserve a couple days to get her affairs in order, or should she come to jail today?
Your Honor, in my opinion, she was advised long ago that jail is very likely today, at today's date. She's had a lot of time to prepare for today. That's my opinion.
Sure.
All right, in this case, the court recognizes that the advisory guidelines would suggest a sentence between 0 and 11 months. Courts can exercise my discretion in sentence consistent with the advisory guidelines and consistent with the plea agreement in this case. Be the sentence of this court that this defendant served 330 days in the Nuevo County Jail. I'll give her credit for the 192 days that she's already served. She's previously violated her probation. She's been to KPEP, which is an inpatient rehab program recently. She's been to a couple other residential rehab places. And, I hope that you can get off the controlled substances, but the system has done what we can for you. At some point, you're gonna have to do it for yourself. And for those reasons, the court is going to direct that you appear at the Nuevo County Jail by 4 o'clock today to begin serving your jail sentence. If you show up at the jail, either having consumed alcohol or any controlled substances, then this deal is off. I'll keep you on probation, and I'll probably send you to prison for violating again. Do you understand that?
Yes, sir.
If you were going to test when you got up here, how would that test turn out?
That'd be fine.
No methamphetamine?
No, sir.
Cocaine?
No, sir.
Marijuana?
No, sir.
All right. Well, they may test you when you get up here, but you have until 4 o'clock to get to the jail. Assuming that you show up at the jail without any controlled substances in your system, the court would then terminate your probation as unsuccessful. You have the right to make applications, leave to appeal your conviction. If you cannot afford an attorney, the court will appoint an attorney to represent you on appeal. Request for a lawyer must be filed with the court within 42 days. That's all for today.
Judge, Linda spoke with Mr. West's secretary, and he didn't have it on his schedule today, so he won't be attending. For Helisinski, Mr. West won't be attending.
All right. All right, let's pull Mr. Helisinski in. All right, we're here on two files, 19-12317 FH and 20-12357 FH. Both these cases are People versus Greg Helisinski. Mr. Helisinski, you were set for a status conference today on both of these files. We contacted your attorney because it was very unlike him not to show up for court on time. If not, he's usually early. But apparently he had a scheduling issue and did not get the status conference on his schedule, so he's not going to be here today. We're going to have to reschedule the status conference. and we'll try and get it back on the court's docket as just as quick as we can. You understand that?
Yes, I do.
All right, that's all for today.
This one is appearing by phone, I don't.
Ms. Murphy, are you on the line?
Looks like they might be muted.
Hello, can you all hear me now?
Yes, what's your name?
Cassandra Murphy.
All right, this is case number 2012458 FH, People versus Cassandra Murphy. Ms. Murphy is appearing via Zoom, audio only. Her attorney, Ms. Frisbee, is present in court. This is set for pretrial conference. Is this going to be a plea, Ms. Frisbee?
I don't believe so. I tried to get hold of Ms. Murphy, her phone is constantly busy. I have not personally spoken with her, but the last time we were in court in July, she wanted the matter set for trial.
Mr. Stay, would you put the plea offer on the record, please?
For the defendant to plead as charged, guidelines are 20 to 46 months on the minimum. The people would cap at 24 months.
Is that the offer that was made to you, Ms. Frisbee?
It is, Your Honor.
Did you talk with Ms. Murphy about that?
I spoke with her in July, and she said she wanted the matter set for trial.
Is that correct, Ms. Murphy?
Yes, sir.
And Mr. Stay, you say as charged, that's with the double drug?
Correct, Your Honor.
And the guidelines at 20 to 46, those are doubled as well?
Correct, Your Honor.
All right. All right, how long is this trial going to take?
2 days, Your Honor.
I agree, Your Honor.
All right, we'll set this case for trial April 14th, 15th, and 16th. We'll start at 8:30. And we'll set this for a final conference. We have a date for Ms. Frisbee in January.
Through January 5th.
All right, we'll set it for a final conference, January 5th. At what time?
Do 8:15.
At 8:15.
Thank you, Your Honor.
Any motions or defenses that you're going to raise, Ms. Frisbee?
Not that I know of at this time.
All right, well, they need to be filed and heard before January 5th.
Okay, got it.
Ms. Murphy, are you still on the line?
Yes.
Do you have a good phone number that Ms. Frisbee can reach you at so she can talk to you before the next hearing?
Yes, I do. Yes, I'll be contacting her or making an appointment to stop and see her.
All right. That's all for today.
Thank you, Your Honor.
Thank you. All right, goodbye.
What's your name, sir?
Randy Wilkinson.
This is case number 20-12384FH, People versus Randy Wilkinson. This case is set for sentencing today, Mr. Wilkinson. And you've executed a waiver of right to appear personally in court for felony sentencing. Do you understand that?
Yeah.
Do you agree to be sentenced via video?
Yes.
All right. And was the pre-sentence investigation report timely made available to the attorneys?
It was, Your Honor.
Yes, Your Honor.
And Ms. Frisbee, have you had the opportunity to read the report and discuss it with Mr. Wilkinson?
We had a chance to review the report. I haven't had a chance to discuss it with him because he's incarcerated. But he has had the report for a while. Hasn't sent me any information that it was incorrect.
Is there anything that you'd like to say on his behalf before the court imposes sentence?
Well, Your Honor, as you can see, he's still incarcerated, and we asked the court to comply with the plea agreement. I think he's been doing well, while he's been there. I'd like to see him out, of course, but I haven't received any information of any misconducts or, any problems that being presented while he's been incarcerated. We asked the court to comply with the plea agreement.
All right, Mr. Wilkinson, have you had the opportunity to read the report and discuss it with your attorney?
Yes, I have. I've read it, but I haven't discussed it.
Do you have any additions, corrections, or challenges?
No, I do not.
All right. Is there anything that you want to say on your own behalf before the court imposes sentence?
No.
Do you want to reschedule this sentencing so that you can discuss the pre-sentence investigation report with Ms. Frisbee, or are you satisfied with its contents?
It's fine. I'm satisfied.
All right, Mr. Stay, any additions, corrections, or challenges?
No, Your Honor.
Anything that you want the court to consider?
No, Your Honor.
All right, in this case, we're dealing with two counts. Count one is receiving and concealing a stolen firearm, being a habitual offender third. The court does find that the advisory guidelines would suggest a sentence between 9 and 34 months. The courts can exercise my discretion and sentence consistent with the advisory guidelines and consistent with the plea agreement in this case. Be the sentence of the court that this defendant served 24 months on the minimum to a maximum of 20 years with the Michigan Department of Corrections. I'll give him credit for the 372 days that he's served so far. There's a $68 state cost. There's a $130 crime victims rights fund fee. Then turning to count two, this is a felon possessing a firearm, habitual offender third. The court does find that the advisory guidelines would suggest a sentence between 9 and 34 months. The courts can exercise my discretion and sentence consistent with the advisory guidelines and consistent with the plea agreement in this case. It would be the sentence of the court that this defendant served 24 months on the minimum to a maximum of 10 years with the Michigan Department of Corrections. I'll give him credit for the 372 days that he's already served, and there's a $68 state cost assessment. The court would direct that these financial assessments be collected through the inmate account and parole process. Count one and count two would run concurrent with each other, and this sentence would also run concurrent with your current prison sentence. Do you have any questions regarding your sentence, sir?
No, I do not.
All right. You have the right to make applications for leave to appeal your conviction. If you could not afford an attorney, the court would appoint an attorney to represent you on appeal. Request for a lawyer must be filed with the court within 42 days, and the court does have your receipt of your notice of appellate rights and request for an attorney that you initialed back in, looks like in July. So that's all for today. Good luck to you, sir.
Okay.
We have Alyssa Saunders.
She might be on the phone right now.
Says she's lodged? She's lodged.
Since 4:45 today.
What was that?
She's
Since
lodged
about
today,
4:45 today.
Oh,
so you guys wouldn't have known about it.
I don't know if she's high or not. I don't know what the problem is.
well, there's someone currently on the phone. I don't know their name.
Well, they're in jail, so she's in jail, so we need to contact the jail and have her brought into the room.
Yep.
Is there somebody in the waiting room now?
There's someone on the phone.
All right, who's on the phone line?
My name is Frank Van Orscott.
Okay. All right, Mr. Banner Scott, it looks like you're represented by Mr. Prysock, who's not here yet. Now he is. This is Mr. Banner Scott.
Yes, sir.
This is case number 2012456FH. And we're set for a pretrial conference today. Is this going to be a plea, Mr. Prysock?
Your Honor, we're asking the court for adjournment. Mr. Vandershot has a case that we just waived the prelim exam, Your Honor, on September 3rd. It was bound over to circuit court. And so we're asking the court to consider adjournment so we can set both cases for pretrial at the same time. I believe it would affect possibly a better resolution.
What's that new charge?
Possession of methamphetamine, Your Honor.
Is that something that is alleged to have occurred while he was out on bond for this case?
It was, Your Honor. I was going to ask the court to address that in some fashion.
So are you asking the court to revoke his bond, given his failure to comply with the terms?
I would, Your Honor. I'm sure that this, unfortunately, my guess is that now with this underlying meth charge, it sort of explains some of this receiving and concealing behavior. I know the defendant's not been convicted of it, but my concern would be drug use leads to more thefts.
I don't do.
Frank, I believe the public would be it'd be a risk to the public to have him now using methamphetamine with this case pending as well.
Right. Obviously, he's entered a not guilty plea to the possession of meth charge, but what facts are you relying on to ask this court to revoke his bond?
Oh, I thought I had this with me. Could the court give me a moment? I could have that file. I thought I had it with me.
Okay.
My apologies.
Hello.
Your Honor, the defendant was stopped on 8/23 on a bicycle. A valid warrant of the 78th District Court was verified during a search of his bag incident to arrest a small baggie was found with a white powdery substance that I believe eventually tested. TrueNarc analysis showed the substance to be methamphetamine, and he was charged with possession of methamphetamine.
All right, Mr. Prysock, any response to the defendant, to the prosecution's motion to revoke the bond?
Yes, thank you, Judge. Frank put up his bond in order to be home and take care of his mother who was ill. I believe this is not a flight risk, it's another consideration for the court. He's got extensive ties to the community. I don't know, I haven't seen any failures with here, but I don't have the benefit of the CCA, so I can't really address that issue since we are not provided with CCHs anymore. So we ask the court to consider a continuous bond. I talked to Frank about this very scenario. My court wishes to make a condition of continuing the bond. We have a drug test, and he said we would be willing to do that.
All right, in this case, the court is going to enter an order revoking the bond in this case, which appears to be a personal recognizance bond. And the court is looking at MCR 6.106, parens I, that it appears to the court that the defendant has failed to comply with the conditions of the release. The conditions of the release that they not violate law of any governmental unit, not use any illegal or controlled substances. The allegations here that there was methamphetamine found in his backpack while he was out on bond for this case. And that being the case, the court is going to revoke his bond and the court would look at setting a different bond upon his arrest and arraignment on the bond violation. So, Mr. Vandershot, are you going to appear voluntarily at the Nuevo County Jail, or are you going to have the officers hunt you down?
I'm confused. I don't know what's going on here. I can barely hear you guys.
Well, the allegations are that you were out on bond in this case, and you were pulled over or stopped on your bike, and you had methamphetamine in your backpack. Obviously, that would be a condition of your bond, so I revoked your personal recognizance bond. And I'm asking you, are you going to show up voluntarily at the jail, or are you going to hide from the police or avoid arrest in this case?
Well, I guess I'll have to turn myself in, I guess.
Okay, what time, how much time?
I've never been in trouble, so I don't know what's going on here.
All right. How much time do you need to turn yourself into the Nuevo County Jail?
I don't know.
When?
I don't know. I don't know what the hell to do here.
All right, I'll give you till I'll give you till 4 o'clock to appear at the Nuevo County Jail.
Today?
Yes, sir.
All right. And how long? And what? I'm confused here. How How come I got a bondsman and I didn't? It's not PR'd. I got a bondsman to get me out, and now it's getting revoked. I don't understand. I didn't do any drugs. They didn't do drug tests on me and everything. I'm confused here.
Well, your attorney can explain it to you.
Okay.
I have it written on my sheet that this was a personal recognizance bond.
No, I got a bail bondsman.
You may have a bail bondsman on the new charge, but I'm showing this case is a PR bond. But 4 o'clock, show up, and you can talk to your attorney. If I've got it wrong, we'll sort it out. And we'll go from there. So you need to be there at 4 o'clock today. The attorney can answer any questions that you've got.
Yeah.
There's a reason I did 36 in that.
That's all for today.
Am I going to have a bond set?
Turn yourself in, and we'll talk about it.
Well, how long do I got to sit before I talk about it? I got a sick mom and some business I got to take care of. I got a business to run. I got other people's cars to tore apart here.
I'm not here to negotiate with you. I've issued.
Oh, okay. I just didn't. I don't know how it works. I'm sorry. I'm not trying to. You know what I'm saying?
That's why I keep telling you that your attorney will answer your questions.
Wonderful. Thank you.
Turn yourself in, and we'll go from there.
Thank you very much.
I don't know if she's seen it. I sent it to her in the mail, I sent it to her by email.
All right, this is Alyssa Saunders. It's case number 19-12224 FH. Ms. Saunders was granted a delay of sentence just back on July 14th, it looks like. And the court received information such that she wasn't abiding by the terms of her supervised release, and therefore she was set for sentencing today. And Ms. Saunders, are you in jail on new charges?
I'm on jail because I missed court.
Okay.
Connor?
Yes.
If I can explain.
All right.
She had a probation violation hearing in 70th District Court, and she missed that hearing, so that a bench warrant was issued. And then she also had arraignment for charges of disorderly obscene conduct, and she failed to show for that hearing as well, and they issued a bench warrant as well.
Okay. All right, so we're here for sentencing today. And Ms. Saunders, do you understand that you have the right to be physically present in court for sentencing?
I don't think I'm mentally stable to do this right now.
Okay. You're asking the court to reset this sentencing?
I guess so, yeah.
Okay. Can you elaborate at all on why you're not mentally stable today?
I've been going through some things in life that are, that they would be unbelievable to people, I guess. In my situation, I'm very afraid. Um, I feel like reality is playing tricks on me. I feel, I feel like I'm being, misled. I feel like I'm being lied to and tricked, and these charges that I keep getting, I'm not trying to break the law. I'm not trying to stay away from my family. I'm not trying to be taken away from my family.
What we just,
I know I
last
have.
time, last time we were in court, we kind of discussed that you had some mental issues. And I was trying to discern whether the alleged erratic behavior was due to drug use or due to mental illness or mental disorders. You did test clean when you went to the drug test. You didn't have any controlled substances in your system. But if you're having trouble understanding the proceedings today, or if you're just feeling like you're just not following what's going on, the court has no problem giving you another date, so your attorney can come talk to you and assess whether you're understanding what your options are and all that. Does that make sense to you?
I guess so. I'm sorry, Your Honor. I'm not trying to cause a
Just be
scene
your
or
thoughts.
anything like that.
I know that my client has been in and out of Pine Rest and to other mental health facilities. When we had these prior proceedings, she was stable. She was taking her medication. She was fine. I can tell today this is unexpected. She didn't think she was going to jail. I don't know if she's been taking her medications, but she's obviously very distraught. I think she needs a little bit more time to adjust to the situation and for me to talk to her.
Mr. Mustin?
I talked to her counselor at meeting mental health a couple weeks ago, and she had missed her appointment then, but he said he would give me a call if he wasn't able to make contact with her. So I assume that she's been in contact with the mental health counselor since then. But she also missed her report date last week, Thursday, too. So she seems to be somewhat unpredictable whether she's going to show the report, what's going to happen.
All right. Ms. Saunders, have you been taking your medications?
No.
All right.
I feel like my medications are fake.
Okay, all right. At this point, we're not going to do the sentencing today. The court will reset her for a sentencing for October 6th at 9 o'clock. So I'm gonna get you some time to get, I'm gonna get you some time to get stabilized, and give you some time to talk to your attorney, and we'll work things through then on October 6th.
Do you think that there's a way that I could go to a mental hospital? Because I am having a real rough time in life right now. Probably for the past year, I've been having a real rough time. And I need some serious help.
Yeah, all right, so they can have somebody come see you, do an evaluation, but, you know, one of the things is that I don't know what help they can give you if you think the medicine they're prescribing for you is fake and you won't take it. So, but I'm not a doctor, I would defer to what they say, but, you know, if you take your medication, that would probably help. So.
I do, I really am taking it.
You just told me you weren't, so.
I said when I am taking.
We're gonna reset the sentencing for October 6th. The attorney will come see you. If you need an evaluation for hospitalization, they can take a look at that as well. That's all for today. Thank you, Ms. Saunders.
Thank you.
Ms. Saunders, you need to knock on the door and let them know we're done, okay? Thank you.
A 12-year-old.
It's 13.
30. Yes. You want to get out of it?
Yeah.
You got to get them to fight. You got to get them on meth. You can take it. Yeah, you got to get them on meth. Which one did you pick? Oh, her. Oh, Reed.
Yeah.
That's coming up. When? 3 weeks. That's so far down the road.
I think you can take.
I got a great witness.
I think you should take one time this one and I should just slide.
Yeah, I have a great witness. I have a great The witness, the lady was given the prop.
No, he's paying attention. I told Chris, and my son said, why is someone joking about dying? It's a 16-year-old girl. The guy was drunk across the street.
Yeah.
Apparently. That was Felix too. I don't impress Wilkinson's with that. She's told me. Hopefully they're. Maybe it is.
1 week.
What is the defense on that case? They stole it.
Nothing left the house, but other than that, yeah, you're gonna lose it. I don't say I'm gonna win any. This one I might.
He's got me, that's fine. It's on the secret.
Christine's already.
He can do all the work and you just kind of.
Working very hard on this.
Christine will have her outline all typed up. She'll say, why don't you go first?
Run. You know we're on.
It's like a scrap piece of paper that he
I already
tore
told
off my.
Oh, you know, that's probably.
What's your name, sir?
Travis Dattoma.
This is case number 2012457 FH. And Mr. Dattoma is appearing via Zoom. His attorney, Mr. Prysock, is present in court. Is this going to be a plea, Mr. Prysock?
Your Honor, I spoke with Mr. Dattoma today in the court. I offered him the jail. But I spoke with the prosecutor here at the courts in our Travis's information. The prosecutor put the plea agreement on the record so Travis can hear what it is and then he can make his decision.
All right, Mr. Stay.
The plea offers for the defendant to enter guilty plea to possession of methamphetamine with the double drug penalty. People calculate the guidelines of 10 to 46 months to be for a negotiated 36 months with the Michigan Department of Corrections. The people would dismiss the original information charging meth lab with the habitual offender fourth offense notice.
So Travis, I think you heard the plea agreement. It's the same as what we talked about when I was in jail. So the judge's question is, are you going to enter your plea or are we going to set it for trial at this point?
No, I'll put in a plea of guilty.
All right.
Judge, for the record, I did take over the advice of rights form for Travis as a review and sign. I think he He's got it, Judge, and I think he signed it and reviewed it, but the court wants to require it down there.
All right, Mr. Dattoma, will you raise your right hand, please? You solemnly swear, oath, or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, in this case, they're offering you to plead guilty to an amended felony information. This lists count 2 as on or about June 30th, 2020, you were in Brooks Township, Weigel County, State of Michigan, and that you committed the crime of possession of methamphetamine, and that you did knowingly or intentionally possess methamphetamine. This is normally a felony which carries up to 10 years in prison and or $15,000 fine plus cost, and unless sentenced to more than 1 year in prison, the court shall impose license sanctions. Do you understand count
Yes.
count 2 and the maximum penalty?
Yes, Your Honor.
All right, now the prosecutor has put you on notice that this is a possible second drug offense, and that you were previously convicted of violating a possession of analogs contrary to MCL 333-74032BA, and that was on or about May 26, 2009. And therefore, upon conviction, you may be subject to an enhanced sentence. This double drug notice could increase your maximum penalty from 10 years to 20, and they also could double the advisory guidelines. Do you understand the added count 2 and the potential maximum penalties?
Yes, Your Honor.
The plea agreement in this case is that you'd be sentenced consistent with the advisory guidelines. The prosecutor scored him at 10 to 46 months. He may be right, he may be high, he may be low, but as long as 36 months falls within those guidelines, your agreement is that you will serve 36 months. The maximum would be set by statute at 20 years. Do you understand that?
Yes, Your Honor.
Is that your complete understanding of the plea agreement in this case?
Yes, Your Honor.
Have you had sufficient time to consult with Mr. Prysock about your original charge, and which was operating a laboratory involving methamphetamine, a 20-year felony, and habitual offender fourth, which could have been a life offense? Have you had an opportunity to talk with Mr. Prysock about your original charges and this plea agreement?
Yes.
Subject to the plea agreement, how do you wish to plead to possession of methamphetamine being a second offense drug offender?
I'd like to plead guilty.
Do you understand that if I accept your guilty plea, that you're giving up your right to have a trial of any kind?
Yes, Your Honor.
Do you also understand that by pleading guilty, you're giving up certain constitutional rights? We've listed those rights for you on a device, the right sheet. Looks like you have that in front of you. Did you read that document?
Yes, Your Honor.
Did you understand those rights?
Yes, Your Honor.
Has anyone threatened you to get you to make this plea?
No, Your Honor.
Has anyone promised you an outcome other than what we've talked about today in court?
No, Your Honor.
Are you entering this plea of your own free will and free choice?
Yes, Your Honor.
Do you understand that if I accept your guilty plea, that you're giving up the right to later claim that the plea was the result of any promises, threats, or inducements that you don't tell me about today?
Yes, Your Honor.
Do you understand that if I accept this plea, that you're giving up the right to appeal any appealable issues you would have if you went to court for a trial and you were convicted?
Yes, Your Honor.
Do you understand that you're giving up the right to appeal this conviction, and if you wish to file an appeal, it would be by application for leave to appeal in the Court of Appeals?
Yes, Your Honor.
Do you understand that if you're on probation or parole, a conviction in this case may subject you to additional penalties in that case?
Yes, Your Honor.
Do you understand that I'm not bound by this plea agreement, but if I don't go along with it, you can withdraw your plea?
Yes, Your Honor.
You now give up your right to have a trial of any kind and all the constitutional rights that you would have at that trial and affirm your guilty plea.
Yes, Your Honor.
Are you pleading guilty because you are guilty or for some other reason?
I'm pleading guilty because I knowingly had methamphetamine, so
All
I'm
right.
guilty.
So it's true then that on or about June 30th, 2020, that you were in Brooks Township, Nuevo County, state of Michigan?
Yes, Your Honor.
Where were you in Brooks Township?
I want to say I was on Thornapple Road, off 82.
Did you say you were at a house or in a vehicle?
I was in a pop-up camper at a house while it was being reconstructed.
Okay, all right. And did the police come out to that area?
Yes, Your Honor.
And did they find some methamphetamine?
They found instruments used to make methamphetamine.
All right, was there any finished product or any residue or anything that actually tested positive for methamphetamine?
Honestly, I don't know. To be honest with you, I have no idea. On my account, there shouldn't have been. But, you know, I didn't get any test results. I didn't get, you know what I mean? So I don't know what, you know, what they have.
Defendant made a statement when he was interviewed that he had used a little bit of the methamphetamine that had been manufactured.
All right, so the prosecutor's indicating that you gave a statement to the police. Do you remember doing that?
I was under the influence, but I'm sure I did.
All right, what were you under the influence of?
I was doing methamphetamine and heroin.
Okay, and did you manufacture this methamphetamine yourself?
Yes, Your Honor.
Okay, and when had you last used that methamphetamine?
The night before. The night before the police showed up.
Okay, and was that at that property where the camper was?
Yes, Your Honor.
Okay, all right. So, are the attorneys aware of any promises, threats, or inducements which have not been stated on the record?
No, Your Honor. There are none.
Is the defendant competent to enter this plea?
He is, Your Honor. He is.
Has the court complied with MCR 6.302?
You have, Your Honor. Court has.
All right, the court does accept the plea. Do you find it to be knowing, understanding, voluntary, and accurate, and agree to be bound by the terms unless the pre-sentence investigation report reveals something I'm not aware of? I'm going to refer you to probation parole for the preparation of the pre-sentence investigation report. They'll send over an information packet for you to fill out. You've probably done one of those before.
Yes.
Oh, I'm sorry. The other thing I need to do is it true that you have at least one prior drug conviction on your record, sir?
Yes. Yes, Your Honor.
And was that on or about May 26, 2009?
Yes, Your Honor.
And what county or what court was that in, do you remember?
I want to say it was here in Nuevo County.
Okay, all right. All right, so the court will set you for sentencing, and we'll set that on November 3rd at 9:10.
Thank you, Your Honor.
All right, that's all for today.
Thank you.
Jefferson. Dana. Yeah. You're a co-boss. That's true. You get enough cases. I was at the same one. Yeah. But. Yeah.
Live stream. Oh, no, so he's coming.
You can even see it.
This is Mr. Barrett.
This is case number 2012459FH, People versus Corey Allen Barrett. Mr. Barrett is appearing via Zoom from the Nuevo County Jail. His attorney, Mr. Prysock, is present in court. We're set for a pretrial conference today. Is this going to be a plea, Mr. Prysock?
I believe it is, Your Honor. We're going to offer a no contest plea for the case.
All right, he also has case number 2012460. Are you going to enter no contest pleas today, Mr. Barrett?
What kind of plea, or I've really never been to court before. I really don't understand too much of court. But, if I do sign this here, that means I give up the right to be tried by a jury, to presume innocent and to prove guilty. Also to have the prosecutor prove beyond reasonable doubt that you are guilty. To have a witness against your, or at your trial, or anything like that.
Well, you give up those rights if you enter a plea of guilty, and when you sign that document, it just says that you've read it and you understand the rights that you're giving up. Your attorney thinks that you're going to enter a no contest plea. Apparently, he's got something worked out for you with the prosecutor. Did he talk to you about that?
Yes.
All right. Did you want to? Hang on. Did you want to go through with what he had worked out for you, or do you want to have your case set for a trial?
Let's go with what he had worked out for me. I just want the best thing possible. I just want to make a home to my family.
All right. Why don't you raise your right hand then, sir?
All right.
You solemnly swear, oath, or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Swear. Truth.
All right, put your hand down. And Mr. Stay, will you put the plea agreement on the record, please?
On 2012460FH, the defendant will enter a no contest plea as charged. Guidelines are 0 to 9 months on the minimum. The people would cap at 6 months. Concurrent with 2012459-FH, where the defendant will plead to an amended information charging 2 counts of assault and battery and home invasion, second degree. The guidelines on that plea are 12 to 24 months on the minimum. The people would recommend no prison, and that would be concurrent with 2012460FH. I've given a copy of that amended information to Mr. Prysock, and I will give a copy to the court right now.
All right, thank you, sir. And Mr. Prysock, has the prosecutor accurately stated the plea agreements in these 2 cases?
Yeah.
All right, so Mr. Barrett,
Yes.
these charges that you're going to enter a no contest plea to read as follows. On or about June 23rd, 2020, that you were in Troy Township, Nuevo County, state of Michigan. This is count 2, assault or assault and battery. That you did make an assault or assault and battery upon Braley Welch. If this offense resulted in damage to another person's property or physical injury or death to the individual, restitution would be required. This is a misdemeanor which carries up to 93 days in jail and or $500 fine plus cost, and a consecutive sentence may be imposed under MCL 5750506A if the assault was committed in a place of confinement. Do you understand count 1 and the maximum penalty?
I guess I understand. I don't really remember too much from when that day happened.
Well, sir, I'm not there yet. I'm just asking you if you understand that that's the charge that you're going to be pleading no contest to. Assault and battery with Braley Welch, it carries a maximum penalty of up to 93 days in jail. Do you understand that?
I guess I believe I do.
I can't understand you, sir.
I guess I believe I do. I'm not sure. I got some high anxiety right now.
What part of that charge don't you understand?
just don't really remember what happened that day, honestly, and I don't know what concurred on that day. I do know that
Okay,
I'm very sorry.
But sir, I'm not asking you what happened that day. I'm just asking you if you understand what the allegations are. That this is what they say that you did.
So that's.
All right.
They say.
All right, stop. Mr. Prysock, I don't think he is tracking what we're doing here today. You need to spend some time with him, walk him through the process, and I'm gonna reset him for a pretrial conference on October 6th at 10 o'clock.
Judge, I agree. I was at the jail to see him. I was at the jail to see him this morning, spent quite a bit of time with him, and I was kind of had a feeling that it could go either way. So I'll go over and see him, spend a lot more time with him next time.
I'm just scared of what.
Roy, don't say anything more, okay? I'll be over to see you. I don't want you to say anything while we're in court, okay? You're not in trouble or anything, so I'll any more trouble. So I'll be over to see you, all right?
All right.
You hold on to those papers, don't lose them, okay?
Okay.
All right, I'll
That's
be over
all
to
for
see you
today.
next week. Was that October 9th, Judge?
6th, October 6th, 10 o'clock. All right, you need to knock on the door and let them know that you're done.
Okay.
You know, I was kind of torn on the other time, you know. First time I talked to him was